All right, let's just see where this goes. What I want to talk about is the RITE-Alignment. What is a RITE-Alignment? Essentially, it is a AI tool, AI prompt, which also includes an essay in order to allow to insert into AI so that it only deals with that subject matter and not the myriad of other subject matters that are available concerning law and equity. So it is a channel, if you will, that shoots specifically to the main topic of what is law. And then it helps the researcher to only deal with that matter and not be inundated by through systemic bias perpetuated by the system itself, which is solely based on our own ignorance of what law is. So that's what the right alignment is. It allows you to interact and through focus by using the AI as a tool or a conduit to explore what law is. Um, Also, I want to add AI. A lot of people are not using it to its true purpose. AI is a reason tool, not a search engine, and additionally, AI is only allotted so many characters in order to answer questions. And the more that you continue on with the more questions without refreshing, like saying a new topic, you will then that AI will begin to distort its answers based on how far you've gone into having these questions answered. So it is always good thing if using AI to stay within at least 4 questions and then refresh, new post, and begin anew and start asking questions. Might be still relative to what you've learned, but then take that learning and then insert it, stop for a moment, take that learning and insert it into the question or question area of the AI so it can you know, reformat itself so it's not trailing all this information with it to make an answer, because it will answer. And I've noticed it more so past. I mean, it's evolving. AI is evolving all the time, but it would give you false answers, even give you case law that didn't even exist. So make sure that if you're going to use anything on AI, make sure that you vet it before you then use it, maybe in any of your documents. Okay, so let's then get back to the reasons why you want to use right alignments, or for that matter, learn what law is. Well, basically, law, and we're going to use the English law. Okay, we're not going to talk about the civil law or the Roman civil law that the French use, and that's still in circulation. Places like Quebec and in the U.S., Louisiana, and other places. It still is a formidable system, but it is not English law, and that's what we want to discuss, because that's mostly what everyone is subject to, but doesn't know what that is in order to understand every other subsequent laws, rules, ordinances, codes, statutes, all of that that have been created thereunder. English law at its foundation is the evolution of the feudal land tenure system. And it is land that is the main principle of English law. It's not people. And that's why you'll never find any contract that people have been looking for, and said, hey, we want the originating contract that compels us to any performance, to serve any, to serve any obligation under government and so forth. It doesn't exist. And I'll get into that in a bit here. But the reality is that it's dealing with land. It puts the use of land, and land itself is not is only descriptive. It's not really speaking about the soil, because at the very apex, no one has a right to the soil to the exclusion of anyone else. It doesn't exist. There's no originating title. People might go into the idea of God and God give man complete dominion. Well, that's in essence the basis of our power, which is an absolute right. And that absolute right is to move freely and use soil as we see fit. And it doesn't exclude anyone else from using that same piece of soil. So land essentially is a right of use to the soil called land. And from there, created a system of rules in order to then govern that use. So use, although it is abstract in some sense, the use has then grown into a myriad of other features, which becomes political territories and so forth, that then govern the use depending on what use that territory has been given. And from there, those rules then, because based on the type of use you've been granted, then you have the right to create those rules based on that use. And there is a use upon a use upon a use, to which I've made in my very first video that we're moving in, or have already moved into, the fourth level of the use, which is essentially no beneficial interest exists and it's all governed by trustees. So which sort of carries me into the second part, or the other part that I said I was going to get back to, but I still want to get back to and inculcate into your minds the premise of what we're discussing here. It is the use that it's annexed to the land itself. They're synonymous with each other, and it is that which then establishes the obligation. That obligation is within the land itself. Okay. It's like when you already mix all the ingredients to make the bread, that all those ingredients are no longer separate and they're in that bread. So look at the use being one of that same ingredient to make the idea of a land interest. And it is your association based on your status and the subject matter that you deal with that then compels you to performance. Now, it compels you to performance, and I just mentioned status and subject matter. And at the apex, the subject matter would be the tenure. Because remember, as I began this, the feudal land tenure system is English law. So it's evolved from, and let's just go, we don't need to go back any further than post 1066 AD and William the Conqueror, and through the Doomsday Book, where he acquired all rights to all property within the area that he conquered, that it has evolved from many different tenures, like military, socage, Franc-Lemont, and there's a fourth one. It's not coming to my mind right now, but there was different tenures that were granted to, well, we'll call it generals, but at that point it would be knights, and who were established as barons, that were given a right to govern over a piece of land. They were given a manor, and then all this other land that then people in the pyramid structure were subject to that baron's will and lord's will. And it evolved through essentially man wanting more rights to the land interest he held, especially after death. So that's how we got into the laws of inheritance, because it was very structured, very rigid in that, it was the baron would have to pass his land interest on to the firstborn son. If he didn't have a firstborn son, that created issues. What about the second, third? What about the females? As you see, all those problems started to evolve because we were finding that there was nothing left over for anyone else, and it was always subject to the original baron having a firstborn son called primogeniture, and that land interest moved to that individual, but also, or to their heir, so that firstborn. And also there was taxes and dues owed, or called incidents, that were owed to the king based once that death occurred. So then there was a lot of pressure onto the firstborn son to hopefully that the father had still value within his land, or had value of a bank account somehow to take care of those interests. If he didn't, now that put the firstborn son into a negative position, and it created another issues. So it was a lot of upheaval. So that's what they created. It started to evolve. Essentially, land interest started involving that men just wanted more rights to the land that they held and taken care of, and they wanted to pass on that certain rights on to others within their own family or secure the families, such like we hear the word dowry, given to the wife 30%, maybe give to the church 30%. Why do that? Because then you don't have to pay on that value of that land because it's given to the church, and so forth. And then you have secondborn and thirdborn, and let's not get into bastards because, hey, you were a bastard. That was the worst position. You had nothing. Okay, you basically a peasant, a serf, even though you were born of a baron or had the seat of a baron or a lord. So all it is that land had evolved through different modalities, certain incidents that occurred where over time, judges heard those issues that arose, and they become conscious of those issues, and then law started to form based on that, giving man more rights to the land that he held while he was living, and giving more rights to pass on, which is called a testament or a will, passing on his intent on to his heirs, not just the heir being the firstborn son. And we finally arrived into 1660, called the Abolition of Tenures Act, which was just totally abolishing the idea of military service and that duty that was a matter that had to be secure, or had to be settled with the king only. And we moved into free and common soccage, and that's what we are today. So what that means, in how I want to speak to it, is on that moment of when it moved into free and common soccage, we moved into a glorious revolution, and then we got into the Bill of Rights, which is basically the Constitution of the people. But it's a agreement between the king and parliament, to serve the law only. No longer the king has the divine right to rule. He's now subject to the law, and that said law, so is parliament. But the law is the people's. That's what I want to get to, that point right here, which is very, it's very instrumental in understanding, because it is that point that people fail or do not know about. It's the law that the people have. Government doesn't have the law, and the king doesn't have the law. They serve under the law or hold the law. And we, the people, have the right to direct the law, but no one is ever there because they are following subordinate under parliament, which parliament has a second level of use to land as administrator. And then citizens have a third who make purchases of what parliament has, government has to offer, which I said now is moving to the fourth. And the people at the apex are directly under the tenure, so that free and common soccage, which, guess what, is held by the king. That's the only title that can hold that interest. And we're not talking about the public oaths and all of that stuff. We're talking about the private changes. For instance, when Queen Elizabeth II died, I think it was in September or something. I don't know the year, don't remember the year, don't care. But immediately at that point, death, the land had to be transferred over to the king and those rights that the queen held. Immediately. That is the interest that we have, because that's the law acting. All that public stuff that happened, so many months later, March or May or whatever happened, and all that, it's just facade. It's for the citizens. It's for those who hold a third level use to land, essentially a fourth level now to land. That's what it is. It's for all the world's a stage. It is 100%. All of it's a fiction. It only creates rules over fictions. All of it. You own nothing. You could never own a logo title, even under English law, because just think about it. Under English law, creates a hierarchical system of land holding, which means there's impossibility of a lodio or a lodium, because you always have somebody's superior right to you, to which you've made purchase or been granted or inherited land. So remember that. People that think that there's some way that they can get, quiet title, stuff like that, there's some interest in that, but you can't get a lodio because you're stuck in the system itself. Now let's get back to the benefit. This is why there is no contract, no agreement, no one ever find one, okay? Remember, a contract needs full disclosure. If you got full disclosure, that means you're a trustee or somebody at the very top of things who then hold the burden of that legal interest. And as such, you would have to have full disclosure in order to make that agreement. Well, why don't you have full disclosure? Well, because I'll tell you why. You're a beneficiary. So directly under the tenure, based on the king holding that tenure, which is essentially holding your dominion right, making sure that's secure, and through the common law interest of the tenure, holds that the entire value of those laws, it secures them. That's why the king can do no wrong, holds that value, to which then subordinately the people would be, I don't even like to say subordinately, but they're beneficiaries, meaning it's not really subordinate in as much as that it's a direct division of titles. So it's principle and attribute. Okay, one cannot operate with the other. The tenure, which is held by the king, that's a full-on fiduciary duty. Okay, that acts as a trustee. That means that king holds a legal burden of all those interests, and that's the interest that king has to administrate over. Beneficial, you have equitable use, meaning that you will receive the benefit. But why are you not receiving the benefit? The simple and direct answer is because you have, am I still recording here? Looks like I am, hopefully. Yes. That that beneficial interest gives you certain rights to exercise those rights, but they're not legal rights because you don't have them. And that's why you don't have full disclosure. And that's why there's no contract you'll ever find, because you're beneficiary. Beneficiary, guess what? It's only action, which becomes an executor action with that equitable interest, is against the tenure, against if the king is doing something wrong. And the king can do no wrong because the law is settled. And that's another thing. If you have an issue of a beneficial interest, you're either dealing directly with the tenure or you're under a trust. That means trustees are now responsible, and it has to be an active trust, whereas at the very top, it's a passive trust. It is an agreement between both parties, whereby that agreement doesn't need to be expressed, because a beneficial interest, you do not need to know. You do not need to know any of the legal parameters of that beneficial interest to be transferred into you because it's beneficial. If it was not beneficial and it commanded you to do something, then you would have to know. Then you would have you would receive the full disclosure of what that obligation entails, because how can you perform anything and be subject to that thing and be obligated to perform anything if you don't have full disclosure? So it has to be beneficial. So that means you have beneficial. But again, you don't ever use, you're never there, because you're fighting within the myriad of laws and statutes and so forth that have occurred under the second level of use to land, under government. If you made purchase, you know what purchase is? Essentially giving you immunity from the beneficiaries. So from yourself, you're giving yourself immunity from yourself, because but again, yourself is defined as beneficial or beneficiary, and you don't even know that it exists. But the law has to make sure there's division, that you don't interfere with that beneficial interest, but that beneficiary also doesn't interfere with you, because it's like landlord-tenant agreement. Landlord has its rights and powers and duties, and as a tenant, you have your rights, powers, and duties. So you can exercise those if the landlord is doing something against those, and vice versa. There are two different things, but you have immunity from that landlord possessing the right over your, whatever he may do. He might think that he can come into your house anytime, and that obviously cannot occur, but would occur if you didn't have those rights in equity as a tenant. But back to understanding, a transfer of a beneficial interest does not need to be explained to you, and you already have that. So it is right at birth. You get transferred that, but you don't have full rights to that because you're not full age to act and understand what that is. But as soon as you reach the full age, which is 18 in equity, 21 in common law, you now have a right to control that interest fully and completely as a beneficiary. But what I would do fully and completely is, using a RITE-Alignment, is get the trustees out automatically, remove the burden for the trustees, take full burden, and now start working towards commanding the legal interest, which encompasses everything. Now you have full possession. I'm not going to get into that at this point, but that's what we're looking to. So I also want to give you another distinction, which is very to use the word for what I'm going to be to explain it, is There is pre-positive law, which is that law that you have a right to, under the tenure, direct under tenure, to petition the king as as a beneficial interest, or to settle that matter and retain that legal interest again. Or you have what the system is, and became more fluid in the late 19th century, is positive law. And that is what you're governed under right now. So all the gurus, everybody else are doing it. Sure, there's remedies in positive law. Okay, you can find them, sure enough, but you're not exercising your true power. You don't have the right to the full law. That's why you still can get railroaded anywhere, and that's why the courts will, beat your ass up, because most people are commingling. They think they want to stand up on this level and say, hey, I'm a living man, I have absolute rights, and blah, 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 and he goes on and on and on, and then he goes into the Constitution, and he starts talking about having a right to property, and he's holding a purchase agreement. Right now, you just commingled. So the court has to automatically put you into constructive trust because you haven't explained where the trust is, so now you are relegated to that level because you're saving yourself from your own self because you don't know what you're talking about. So anybody that's talking any of these things are not giving you ever. They're talking about law, and that's what the right alignment is for. And that's maybe what I could end it on this. I will send the link. I'll create a link to the right alignment. Yes, there's a value. I'll tell you what. Hey, I put my sweat equity into understanding all of this, and you will never. And I'm going to be candid here. You'll never get to a point of full resolution and full freedom by following or not understanding what law is. And the only way to do that is either A, start going through the right alignment and start learning what law is, and which is the easier, most direct way, because I've already gone through the understanding to then input into AI. Or you can do, hey, there's free stuff online. There's Black's commentaries. There's all of his books. There's all of those laws. There's the Maitland's, these true legal scholars talk about what law is. You can start dissecting all the things that I had to dissect to get here. And it ain't going to cost you anything except your time. So there is a value. It's right now at £40. I'm going to move it up to 99 Canadian. And that's what's going to be sold at that price. Or there's also a free part of it called Right Alignment. It's just an introduction of what I've sort of discussed here. But you have the choice all the time, okay? And I am moving now into what I can quantify as like the checkmate position, that I've created a document. Don't know if I'm going to share that yet, but I think what I should do is use it first to verify its power. But it's also going to involve some time, because now I got to go to court in order to fulfill its power. And it's only the court that can actually assign you the trustees and so forth. And I don't think any of these attorney generals or governor generals or anybody else really understands law. And it has to be discussed with a judge that is a competent judge who's using full judicial independence in order to discern the matter. And through that document that I've created, like I said, the shorter the better. It's only like 2.5 pages. It says it all. And it only deals with what I'm talking about, the law. And with that, I'll close. Thank you for listening. And hopefully I'm going to start doing some more videos as I start discussing some of the things that I've encountered. And I'm always tweaking to make sure it's perfected, that there is no wiggle room on their side, and they understand their position. And of course, I have my position, I have the law, and so do you. God bless, and I mean that in that you are all of that. It is in that very moment of all existence, you are the power. You do wield that power, and that's what the system is most fear of. Thank you. Have yourself a great day.